The case that we are covering is Nunnery versus Awesome Toyota in Mississippi. The facts of the case: against company policy, Scrub, an employee of Awesome Toyota, used a company car during his lunchtime without prior authorization from his supervisor. While using the vehicle, he was in an auto accident. Fact number 1, is Awesome Toyota liable for Scrub's actions? Fact number 2, are Billy and Baxter Biz individually liable for Scrub's actions? One legal authority that supports the cases are the law exacts of every agent and employee diligence and good faith, obedience to instructions in the execution of his agency or employment, and holds him liable for failures therein. It is, of course, established that the master is responsible for the torts of his servant only when they are committed within the scope of employment. The test used to determine this is when the employee's torturous act is within the scope of his employment, whether it was done in the course of and as a means to the accomplishment of the purposes for which he was hired for. Where the relationship of master and servant is shown to exist, it devolves upon the master, the business, Awesome Toyota, in order to escape liability for the acts of the servant, to prove that the servant had abandoned the duties of his employment, he was on his lunch break, and had gone about some purpose of his own in which the master's business was not concerned, and which was not incident to the employment for which the servant was hired. The general rule is that the master is excused from liability for the torturous act of the servant when committed outside the scope of the servant's employment. This rule governs all cases where the servant abandons his master's business and engages in some purpose of his own. Conclusion. Fact issue number 1, is Awesome Toyota liable for Scrub's actions? No. Based on the facts of law, Awesome Toyota as a business is not liable for Scrub's actions. Scrub is an agent of Awesome Toyota while performing duties within his scope of employment. However, the accident occurred while Scrub was outside the scope of employment. Fact issue number 2, are Billy and Baxter Biz individually liable for Scrub's actions? No, Billy and Baxter Biz individually are not liable for Scrub's actions. Scrub's actions was a result of his own personal benefit and did not fall within the scope of employment for which he was hired to perform.